Deciding whether to plead guilty or not guilty to a criminal charge is perhaps the most important issue you will discuss with your lawyer. Your lawyer will request police evidence and will provide you with an assessment regarding the strength of the prosecution case. If the evidence is weak, your criminal lawyer may advise that you plead not guilty and defend the charge. However, if the evidence against you is strong and the prospects of a conviction appear likely, then the advice may be to plead guilty. That is because there may be some benefits to you in pleading guilty. A plea of guilty at an early stage will spare you from lengthy and protracted court proceedings. But more importantly, it may also afford you a significant discount on the penalty that is imposed upon you by the court. Under the Sentencing Act of Western Australia, the discount in the sentence for entering a plea of guilty can be up to 25%. However, before pleading guilty, there are 3 fundamental rules of law you should consider. 1. The presumption of innocence. All criminal proceedings commence with the accused presumed to be innocent, and you are presumed innocent until either a guilty plea is entered by you or a jury finds you guilty. 2. The burden of proof rests solely with the prosecution. It is for the prosecution to prove the charge against you, and at no point are you required to prove your innocence. 3. The prosecution must prove its case against you to the required standard of beyond a reasonable doubt. This is the highest standard of proof known to our law. It's not enough for the prosecution to tip the scales and prove that the accused probably committed the offence. The standard of proof that the prosecution must meet is beyond reasonable doubt. Whilst there are other matters to be aware of, if you are pleading guilty, if you are charged with an offence and you want to ensure that your interests are safeguarded, call the criminal law offices of Andrew Williams to get advice about the best pathway forward.